Companies Act, Section 446A, Detailed Factors for Determining the Level of Punishment. Section 446A of the Companies Act, 2013 lays down a structured framework to help the court or the special court decide an appropriate punishment when an offense under the Act has been committed. The intention of this provision is to ensure fairness, proportionality, and consistency in awarding penalties such as fines or imprisonment. Instead of treating all violations the same, this section mandates a careful evaluation of specific factors related to the company and the nature of the default. 1. Size of the company. The scale of the company's operations is a major determinant in assessing penalties. Larger corporations often possess greater financial strength, access to professional expertise, and stronger compliance structures. Therefore, if such a company commits a violation, it may be seen as a serious lapse in governance, warranting stronger punishment. In contrast, smaller companies with limited resources might face less severe consequences for comparable defaults. This factor ensures that penalties are equitable and not excessively burdensome on small enterprises. 2. Nature of business carried on by the company. Different industries carry different levels of regulatory risk and public impact. A company operating in sectors like finance, insurance, infrastructure, healthcare, or public utilities is expected to follow stricter compliance obligations due to the sensitivity of such businesses. Misconduct in these sectors may result in widespread economic or social harm. The court considers how crucial the company's activities are to the economy and public welfare, and penalties may be higher for businesses operating in highly regulated or high-risk fields. 3. Injury to public interest. Offenses that negatively affect the public, investors, creditors, employees, or the market at large are treated with heightened seriousness. This factor ensures that corporate misconduct resulting in significant public loss or risk does not go unpunished. If the violation undermines trust in the corporate sector or causes financial harm to stakeholders, stronger punitive measures may be imposed to protect public interest and uphold corporate accountability. 4. Nature of the default. Not all offenses are equal. The court examines whether the breach was a technical or procedural lapse, a negligent act, or a deliberate fraudulent wrongdoing. The degree of intent or recklessness behind the violation plays a crucial role. Serious offenses like falsification of accounts, fraud, or willful concealment of information will attract stricter penalties, while unintentional or minor defaults may lead to more lenient treatment. 5. Repetition of the default. A company's compliance history is an important indicator of its attitude toward the law. If the company has previously been found guilty of similar violations and continues to disregard compliance obligations, the court may impose harsher consequences to discourage persistent non-compliance. Repeat offenders may face escalated penalties to reinforce the deterrent effect of the law. For more details, contact us.